almost all of the protections that individuals, citizen or not, enjoy in the United States to protect them from the government comes from the first 10 amendments to the Constitution, known as the Bill of Rights. Maybe a long time ago, the people have to recall in civics classes hearing about the Bill of Rights. But the story behind the Bill of Rights is that the Constitution was drafted in Philadelphia and went out to the 13 colonies to be ratified, and the colonists rejected it. Why? Because they saw that without certain individual protections, there was going to be a repeat of the kind of bad government experience that they had in England that they were leaving from. You know, King George didn't allow for any individual rights. There was no freedom of religion. There was no freedom of press. There was no right to bear arms and form militias. There was no protections against unreasonable searches and seizures. There was no protections against the right against self-incrimination. And there was no guarantee of effective assistance of counsel. So almost all of the things that I do are wrapped up in these first 10 amendments of just a few that I have highlighted. The most important one, from which I think all the others flow, is the Sixth Amendment right to counsel. The Constitution says that an individual has the right to have not just the right to counsel, but effective assistance of counsel. And even though the Constitution said that, for almost the first 200 years of our nation, there was no system of public defenders. It wasn't until 1963 that an individual who had been convicted of a petty theft in Panama City, Florida, appealed by writing from Florida State Prison his own petition to the United States Supreme Court saying that he was unjustly convicted because he didn't have an attorney to represent him. And in a lot of ways that made sense. There was an attorney for the prosecution, the judge was an attorney, and an individual who was not trained and experienced in the area of law having to defend themselves against a criminal accusation really didn't stand a chance. So this individual who's become famous, his name is Earl Clarence Gideon or something like that, Earl Gideon. Earl Gideon petitioned the United States Supreme Court, and it's very famous that the United States Supreme Court required now that individuals accused of a crime who were facing prison or jail time and a loss of their liberties were entitled to have court-appointed counsel. And when Gideon's case came back it was reversed and remanded, came back to court in Panama City. He was represented by an attorney, and he was found not guilty. So, you know, it's a very patriotic thing. I love to wrap myself in the flag, and I think that what I'm doing as a criminal defense attorney is the most patriotic thing that I can do to demonstrate my love for this country by making sure that individuals, without me having to judge them, because that's not my job, that's the judge of the jury or the job of the judge, but to make sure that the Constitution is real and alive and that individuals have effective assistance of counsel as guaranteed by the Sixth Amendment to the Constitution. Now, to turn the page, what happens when an individual does not have effective assistance of counsel? We have developed a very highly refined and efficient practice in the area of post-conviction relief, where we represent individuals who have not had effective assistance of counsel, have lost their appeal, and are now within a 2-year window to try to come back and to attack their appeal. I can tell you that there was recently a case that we had where an individual we represented entered a plea, was sentenced. He appealed the sentence. The sentence was reversed. And when it came back, a different judge imposed the same sentence that he had in the first place. When we got to the case, we reviewed the matter, and it turned out that my client, who had been convicted of jury tampering, three counts of jury tampering, should have only been convicted of one. So we made a double jeopardy argument. We made an argument that my client had ineffective assistance of appellate counsel, and the appellate court looked over the pleadings and what had happened and decided that we were correct in our interpretation of the statute, that our client could have only been convicted of one of the three offenses, that the two of the offenses he should never have been convicted of, that his appellate counsel had completely missed the issue, and the client went from having a 15-year sentence to having a 5-year sentence. We went to court. And when we got to court, the judge made an order for the defendant's immediate release from prison, and that guy got 10 years of his life back, just like that, because he knew enough to call us. We had another situation where an individual was convicted of, entered an open plea to court, and was sentenced to 20 years in prison, but his attorney failed to advise him of what his exposure was when he entered the plea. And that mistake caused the defendant to enter the plea that had he known what he was truly facing, he would not have entered the plea. And his sentence went from 20 years to 5 years. And I can tell you, even though I've received so many, great outcomes in criminal defense cases over the years of having clients found not guilty, it's a new thrill and a new excitement to have somebody who is on their last gasp of breath before their sentence becomes final and there's nothing that can be done about it, to have their sentence cut and for them to be released. It's amazing.